Good evening, USA. Thank you everyone for joining the Living Trust and Will seminar organized by Bay Malayali. It's our privilege to host attorney during this event. And this is as part of our financial literacy series initiative. The initiative is led by John Codian. So I hereby welcome Bay Malayali Vice President, John Codian, to take it forward. And John, over to you.
Thank you, Lebon. So, Bay Malayali had gone through a couple of experiences meeting people with the financial problems. So that makes us think how to address, how to inform our community the need for having this financial literacy. That means, financial literacy is the skills and knowledge what you have to take effective decisions on your financial items, resources, wills, items like wills and legal items and trust and like that. So while we are thinking, the first thing what we plan for a series of financial literacy programs. The first one we did is a short film. It started with a short film with an idea of educating the people, our community, about the financial literacy. You might have seen that movie. It was named Interstate. Interstate, the word means a person died without a will. So the laws here are entirely different than from your country you immigrated from. So for like in India, things will happen very easily. Here, it won't happen. So we took such a story and told a story what will happen here if you are not have taken actions in your financial resources, accounts, and all those, what is going to happen. So it was a good hit. Within 2 months, it was already past 23,000 views across our community. So this is another set of another program on the financial literacy series. After the movie, we started getting a lot of messages, emails, phone calls. I want to do this. I want to do a will. How do I do a trust, living trust? How do I do many questions? So this is the second part of our financial literacy program. And we have a well-known guest here, Swapna Anthoor. She's an attorney to address all your questions about your living trust, wills, and such financial planning matters. So I welcome Swapna to present that information to our audience.
Thank you. Thank you, Bay Malayali, and all of the organizers in this event. I believe it's a very great initiative by Bay Malayali to educate people, especially people from India, who do not understand the consequences of passing away without having a will or trust. And I have seen the movie Interstate, and I find it's very educational and it's very informative. And I believe it really would open the eyes of many people who are clueless about how things are processed in this country, in US in particular. That being said, I have let me introduce myself. My name is Swapna Anthoor. I am an estate planning attorney. Our office is based in Fremont, California. And estate planning is one of the area we practice quite a lot. And we have practiced it for 6 to 8 years in this field of estate planning. So we help people prepare their wills and trusts and the entire estate planning package as part of our practice area. So today my goal is to give a presentation regarding estate planning. I want to educate our community regarding what estate planning is, why is it beneficial, and why it's important to get it done. Okay. That being said, a lot of people might be aware what estate planning is, but I'm sure there are a lot of people who are not aware what estate planning is. Estate planning is a process by which you plan the passing of once you pass away, how your assets are passed on to your beneficiaries by the way of wills or trusts. Apart from that, another important element in an estate planning is you're also taking care of guardianship of your minor children. Many of you might not be aware that in the event both parents pass away, and if they have minor children, anybody under 18 years of age, the custody of the children by default goes to the government, and the children could be placed in foster care. And that's something most of us, me being a parent myself, it's totally undesirable. You don't want your child to be in a broken system such as foster care, where the funding is given by the government, and this is their motive. I mean, the more children they have, the more funding they get. So this is how they run the system. So we would rather want our family or friends to take care of your children rather than having them go to foster care or any of those kind of situations. So we can take care of the guardianship of your children. It might not be the exact guardianship paperwork or guardianship or custody paperwork that you're doing, because while the parents are alive, it's not possible to do that. So by nominating guardians for your children, either temporary or permanent, you are nominating these people to take care of the custody of your children immediately, in case something happens to both parents. In the movie Interstate, it deals with a situation when one person is clueless about the finances, and she is not a joint account holder, not a joint owner in any of other assets, and is left in the lurch once the husband passes away. And that's really definitely eye-opening. But at the same time, we need to address this aspect also. What happens when both parents pass away, and what will happen to your children? Okay. So the purpose of doing estate planning is to avoid 3 different court situations. One is probate, second is guardianship, and the third is conservatorship. So probate, let me educate about probate, what probate is. That will give you a better understanding how the system works.
Swapna, I think you might need to share the screen, the PPT, if you haven't.
All right, thank you. Sorry about that. So, yeah. So estate planning is essentially a gift for your family. It's an action plan for you and your family's present and future. And it's also about managing your assets and wealth. There's also a safety measure and a security measure, and it's an investment in your children's future. So, as I said, estate planning helps us avoid probate, guardianship, and conservatorship. So let me explain a little bit about probate. Probate happens when you pass away without any trust, or even if you just pass away just by writing a will. So what happens at that point is somebody in your, an interested person in your family members will have to petition the court to open a probate case, because all your assets will be frozen at this point. And once it is petitioned with the court, the judge appoints the personal representative for the deceased person's estate. So the personal representative's job is to make sure they send out notices to all beneficiaries and any creditors or anybody, any other interested party in your in the deceased person's estate. But once after doing that, if there is any creditors whom the deceased person owed money, they can file a claim at that point with the court. And during this probate process, when all the assets are liquidated by the personal representatives appointed by the court, that any kind of creditors will be paid off if their claims are valid, and any taxes or any other kind of administrative expenses will be paid off. And after paying all that off, whatever is remaining will be distributed among the beneficiaries. So this process can take around like 9 months to 2 years, or sometimes even more than that. Not only that, the probate, there is a probate attorney's fees involved. So when you have a probate case, you need to hire a probate attorney, and their fee is based on the statutory fee scale. So this is how it works. So first $100,000 worth of assets are charged 4% of the total worth of your assets, estate. And the next $100,000 charge 3%. The next the next $200,000 charge, I think it's 2%, and it's 1% thereafter. So imagine, let's say if you have an assets worth $1 million. If you're in Bay Area and you own a property, you own close to $1 million in value, right? So most of the homes here are close to $1 million, and they look at not the equity of your home, they look at the total market value of your home when they're calculating the value of your estate. So you're pretty much, most homeowners are within that category already. Okay. So that being the scenario, I do not mean to say that only homeowners need to do estate planning. Pretty much everybody needs estate planning. Okay. So if your assets are more than $165,000 in value, it has to go through probate court. If it is less than that, you can use an affidavit of death of small estate and you can take care of the assets. But if it's more than that, you will have to go through probate. And the flip side of having a probate court situation is there will be disputes. Let's say if there are any family members who think they might be an interested party and they are entitled to an X amount or whatever that is, there could be disputes. And of course, the court will resolve it. But however, you can take control and charge of all these disputes by preparing your own trust and wills and addressing how you want your assets to be distributed when you are no longer there. Okay. And apart from the issues that I said, it's time consuming, it's expensive, and it's also a public record. Probate is a public record. So anybody who has gone through a probate court situation might be aware that whatever all the paperwork that's filed, it's a public record. Anybody can go to the court. They can take a copy of all your court documents. And I don't know, maybe there might be some people who will be interested in looking at who the beneficiaries are, how much they inherited, and they might reach out to them and try to con them in one way or other. So it's better that we all keep our financial assets more private rather than keeping it as a public affair. And yeah, that being said, I also mentioned that the guardianship of your minor children are also addressed in your estate planning. That is addressed on the will portion of your estate planning. So you can nominate temporary and permanent guardians. Temporary guardians are the people who will take care of your children immediately. So they could be local. So let's say you don't have any family members here. Let's say all your family members are in India. You have some family friends who you're very close with. You can nominate your friends as temporary guardians of your minor children and nominate your permanent guardians as your family members in India. So immediately your friends can take over the custody of your children if something were to happen. And eventually the permanent guardians, your family members can come over. They'll have to get a proper custody order from the court, but still it's better. Your temporary guardians can take care of them in the meanwhile. And eventually once the court gives them custody, they can take the children to India if that is necessary, or if they have to be in US and somebody take care of them, that is also possible. So there are other documents also that's part of estate planning, which is Advanced Healthcare Directive, Power of Attorney, and HIPAA, which are the documents that will help avoid conservatorship. I'll get to that in a few minutes. So let me address what kind of documents estate planning consists of. So these are documents as part of estate planning. You will have a certification of trust, which is kind of like an ID for your trust. So that's the document you need to provide your financial institution to let them know that you have a trust and you want to probably move or fund your assets into the trust. And there will be another document called the funding instruction that will help you understand how to move or fund each and every one of your assets into the trust. And you'll have the revocable living trust. This is the main document. This is a document that will be there for a while. You will be nominated as the initial trustees of your trust, and you will also nominate any successor trustee to manage your trust when you are gone. And there's a trust summary, which is a summary of the revocable living trust. And there are 4 over wills. It'll be one for each couple. So one for the husband, one for the wife. This is where you'll also nominate guardianship for your children. And you'll have a power of attorney, and you will have advance healthcare directive and a HIPAA. So those are the documents that power of attorney will give the people you nominate the right to make financial decisions for you when you're incapacitated. It is valid from the time you're incapacitated till you pass away, only for that short duration. And healthcare directive is the document that will give the people you nominate the right to make medical decisions for you when you're incapacitated. And HIPAA is a document that will give the people you nominate the right to access your medical records. And you'll also have another document called the assignment of personal properties, whereby you'll make a statement that all your tangible, movable personal properties like jewelry, cars, your personal belongings, your expensive watch, all these things are becoming part of the trust, because those cannot be retitled, or it cannot be funded by any other means. So this is the way you can take care of your personal properties. And there is another document called the personal property memorandum. So this is a document that if you want to give itemized distribution of your personal properties to your beneficiaries in any specific manner. So let's say sometimes you might have a preference that I want to give this car to my son, or this jewelry to my daughter, or this watch to my grandkid, or whatever that is. You might have some kind of preferences. It's not necessary that you use this document, but if you have such preferences, you can write it down in this document. You can, in the left-hand column, you can list what item it is, and correspondingly to the right-hand column, you can list who's going to receive it. You can date and sign that document. So when eventually the distribution of the personal property happens, the trustee will need to go through these documents and distribute to the appropriate person. Okay. And there will be a trust transfer deed. That is the transferring of your real property into the trust. So the main assets most people would have here is the real property. So you need to retitle this real property into your trust, and without doing that, the house will not be part of the trust, and it will trigger probate. So we want to avoid that by creating this trust transfer deed and recording it with the county wherever your property is located. The house becomes part of the trust officially. Okay. And there may or may not be any trust amendments. So if you want to make any changes to your trust in the future, like you want to change some terms, you want to change your trustees, you want to change your guardians, you want to add a new beneficiary or change beneficiaries, you can do all that during your lifetime. And that is done through a trust amendment. Yeah. So what kind of assets are included in your estate planning? So pretty much all your assets in the United States. I mean, we can only include your assets within this country to be part of this estate plan. It can be assets from any other state also. If you have assets in Florida, or let's say Texas or any other state, they can also be part of, let's say if you're creating a trust in California, they can all be part of this California trust. If you have assets in India, that has to be dealt separately. We can help prepare a will for your assets in India separately. That's a totally different process. Okay. So as I said, the purpose of having an estate planning is to make sure you can control over who receives your assets when you pass away, when you decease, and to make sure the probate is avoided. Don't want to go a family to deal with a probate court situation when they are already grieving your demise. It will be too hard on them. And conservatorship avoidance. Conservatorship happens when you're incapacitated. I'll get to that in a little moment. And also to set up guardianship for your minor children, as I explained earlier. Okay. So let me talk about what is the purpose of a will. So what is a will? So will is a traditional legal document which names individuals or charitable organization who will receive your assets after your death. This is a very simple document. It's not as complicated as a trust. So you can even handwrite a will if you have to. It's called holographic will, as we say it. You can write down that you are of sound mind, and you can identify your assets. You can identify your beneficiary in the document. You can specify how you want your assets to be distributed to your beneficiaries. If it's your spouse or your children, or if it's anybody else, you can specify how that is distributed and what percentage is distributed to them. So all that items can be captured in a will. Okay, but will has to go through the probate court. So whatever I explained about probate will still happen if you only write a will and not a trust. But the only advantage is the judge will read the will, and instead of using his own discretion or the state laws, the judge will use your will and distribute it accordingly to your beneficiaries. But again, the time, the money, and the hassle and the public record part, everything will still happen. So just leaving down a will is not the best case scenario. But if you don't have much assets and it's very limited, you can still just write a will and leave it at that. And the will also nominates an executor. We also call the executor the personal representative. The personal representative is the one that is nominated by or appointed by the court to manage your probate case till it's completed. Okay, it can be somebody you choose in your will, or the court will appoint one person. Okay, and you also nominate guardians for your minor children. Okay, as I said, you can have temporary guardians or permanent guardians. Temporary guardians should be local, and they should be able to immediately take custody of your children. The permanent guardian can be out of country. That's completely all right. And apart from doing a trust or will, is there any other means of leaving property to your beneficiaries? Yes, there are. These are some of the examples. So one way is, if you have a life insurance, you might be aware that you're asked to designate a beneficiary through your life insurance. So in case something happens to you, who's your first beneficiary? Most of them would be choosing their spouse if they're married, or the secondary beneficiary would be their children, and anybody else if they want to. Or they can also choose to give it to a charity or any other family members or friends if they want to. That being said, a life insurance policy, you might not want to nominate your minor children as the beneficiary in your life insurance policies, because when you pass away, and let's say your kids are around like 10 to 12 years of age, they are not going to get the proceeds of the life insurance policy at that age. They will have to wait till they are 18 years of age. Okay. And at 18, they will get a check for the entire amount. So if it's $1 million policy, they'll get a check for $1 million. And you don't know what an 18-year-old with $1 million check is going to use it for, right? I mean, they could just blow it off in a few years. So that is where you have to do more better planning and create a trust, and maybe add the trust as a beneficiary rather than adding your minor children. Okay. And there are other means of leaving property. One is qualified or non-qualified retirement plans, including the 401k plans and the IRAs. Again, that is also a beneficiary-driven account. You can nominate primary, secondary beneficiary, or contingent beneficiary in those cases also. Again, as I said, minor children, they will not get if something were to happen to both the spouses, minor children will not get the distribution until they are age 18, and at 18 they will get a lump sum of whatever they are entitled to. Okay. So again, if you have a minor children, I would rather nominate the trust as a secondary beneficiary, leave the spouse as a primary beneficiary, and the trust as a secondary beneficiary. And there are certain trustee bank accounts, and there are transfer on death accounts and a pay on death accounts. So most of us might not be aware that there are beneficiary-driven accounts like pay on death beneficiary-driven account or transfer on death beneficiary accounts. Those kind of accounts avoids probate. So if you have a TOD or POD account, whoever you're nominating as a beneficiary, when you pass, the funds on that particular account will be distributed to the beneficiary that you have nominated, and it will not go through probate. Okay. And as I discussed earlier, what will happen when you become incapacitated during your lifetime? So when I talk about incapacity, I'm talking about mental incapacity. Like say you are in a coma, or say worst case scenarios, an irreversible coma or something like that. You are unable to make any decisions for yourself. You are not able to manage your affairs. You are not able to do anything for yourself. You need somebody else to represent you and do that for you. So what happens? Let's say somebody suddenly gets into a coma, and what happens at that point? Their family members or any interested party on their behalf will have to petition the court to open a conservatorship case. Once that is done, the judge will appoint a conservator, and the conservator will manage everything related to the incapacitated person. Their financial affairs will be taken care of by the conservator. Their healthcare decisions will be taken care of by the conservator. So everything will be handled by them. Essentially, it's the conservator who's doing everything for the incapacitated person. So you cannot, once you're incapacitated, you cannot make any decisions. You cannot even make any choices to appoint certain person as your conservator, because you lost your capacity by that time. So what you can do to avoid that kind of situation is you can nominate financial agents for you through a power of attorney. You can nominate healthcare agents for you through an advanced healthcare directive. And also you can nominate HIPAA agents who can also access your medical records. So by nominating somebody as your financial agents through a power of attorney, they will be able to make all financial decisions for you while you're incapacitated till you pass away. And the people you nominate under healthcare directive will make healthcare decisions for you, whether to go forward with a certain treatment or not, because the doctor will ask, generally you have to consent for your treatment, and if you lose your capacity, you need somebody else to do that for you. So it is a conservator who does that in this case, in this scenario. But by nominating a healthcare agent through a healthcare directive, they will be able to make medical decisions for you. So you don't have to go through the conservatorship process if you have your healthcare directive, power of attorney, and HIPAA. And by HIPAA, you're also giving those people the right to access your medical records. So if your family members or somebody needs access to your medical records for whatsoever reason, it could be even, let's say, once you pass away, let's say there is some need for your life insurance policy holder as for a medical records to find out the reasons, cause of the death. Or let's say there is some there's a medical malpractice that led to the death. So if your family wants to sue the hospital or the doctor, they will need to have access to the medical records, without which they will not be able to pursue the lawsuit. So it might be a good idea to nominate certain people, somebody close to you, to have access to your medical records just in case. Okay. So again, so conservatorship is done through the probate code itself. The procedure is a little bit different. It's unlike probate, this is called a conservatorship. The judge will make a determination that you're unable to manage your finances because you're very vulnerable at that time. You might not be able to resist fraud or undue influence when you do not have a capacity at that time. So that's why they will nominate somebody to make those decisions for you. And the court would then appoint a conservator to manage your assets for you, and the conservator would report back to the court on a regular basis. So that's also part of the conservator's duty. They will have to report to the court just to make sure the court is appraised of what's happening in your case, and there is no any kind of fraud or undue influence or anything happening in the scenario. Okay. And as I said, you can avoid all that by doing your power of attorney, healthcare directive, and HIPAA. And a lot of time people ask, what are the different kind of trust, and what is the kind of trust that I will need in most case scenarios? Okay. So these are the different kinds of trust that I can run you through. First one is called the revocable living trust. This is the most common trust, and this is the one that's very flexible. You can make any changes to this trust during your lifetime if you have to. It's very flexible and amendable and easy to work with. And the second one is a special needs trust. That's a special needs trust is a trust. If you have children with special needs, you might also want to have a special needs trust so they can keep getting their government benefits and also inherit all the trust assets. I'll explain more of that in a little bit. And there are irrevocable trust. Irrevocable trust, as the name says, you cannot revoke it. So you don't have any flexibility, unlike the revocable living trust. But the purpose of an irrevocable trust is to mostly save taxes, and also if you are in a very vulnerable situation where you will be sued, and or that is a foreseeable situation that you will be in a situation where you'll be sued, and you want to protect at a certain portion of your assets, you might want to create an irrevocable trust, and that'll help you save you from creditors. But the flip side is you don't have any flexibility. The people you have appointed as a trustee, they will manage it. You can nominate your children as a beneficiary or somebody else as a beneficiary. They will get all the benefits, but you won't be able to serve as a trustee or be the beneficiary. That's the flip side. But it'll help save some taxes and also save you from creditors if that is the situation. And there is an irrevocable life insurance trust. So as of now, the federal exemption limit is pretty high. It's 11.7 million per person as of this year. But in a few years ago, it was close to 1 million or 2 million of federal exemption limit. So if you have $1 million life insurance policy, you might want to take it in a irrevocable life insurance trust rather than putting it directly into allow it to come into your estate directly, because there will be tax consequences out of that. So you can create this at this time. It might not be necessary, but we will see how the taxes in the current administration is going to change. As of now, we are pretty good. It's 11.7 million per person. It may change, it might go down. I'm not sure. So we will keep an eye out. And if it goes down, then you might need to do more advanced planning. Okay. And there are charitable trusts. So if you want to set up a charity and have some kind of trust associated with it, you can create a charitable trust. And there is another one called the qualified domestic trust. This is created when one or both of the grantors, the people who are creating the trust, are non-citizens of this country. They might want to create a qualified domestic trust. I'll get to that in a little bit. Okay. So, excuse me. What is an irrevocable trust? So as I stated earlier, it cannot be, as the name says, it's irrevocable. You cannot revoke it. You cannot alter or change or modify after you create one. So that's why you might want to, if your assets are more than the federal exemption limit, you might want to create an irrevocable trust in order to save some taxes. So for a couple, as of this year, is 11.7 for one person. So together you will have, I would say 23.4 million together for a couple worth of exemption. So I think as of most people would be within that range, I'm guessing. But if it's more than that, you can look into setting up an irrevocable trust. And also we can look if the taxes are changing, if it is rolling back, you might want to also consider doing one. And also there is, as I said, there is an irrevocable life insurance trust. As I said earlier, it's not an issue right now with the high federal exemption limit. We are pretty much covered. But if it ever rolls back, you might want to acquire life insurance policies through an life insurance trust. And what is a special needs trust? As I discussed earlier, if you have a child with a special needs situation like autism, or if they are within some kind of spectrum, you might your children might be entitled to governmental benefits, including Medicare and everything, and also Social Security, disability, and whatnot. So you want these kind of benefits to keep coming in, but once you pass away, and if they inherit significant amounts of assets in their name, they might get disqualified from these government benefits. So the purpose of creating a special needs trust is to put all your child's inheritance in the special needs trust. If it is a special needs trust, the government does not consider the trust when they are calculating the beneficiary's income or assets. So they will still get the governmental benefits, and it'll help them to continue get that. And also they'll be able to get the benefits of the special needs trust through the trust. You will also nominate a trustee. Okay. And what is a qualified domestic trust? Qualified domestic trust, as I said, when one or both of the spouses are a non-citizen, there could be, you might need to create a qualified domestic trust. That will be generally we do it as part of our revocable living trust itself. Generally between a US citizen spouses, they have unlimited federal estate tax exemption. That means they can transfer any amounts of assets between each other tax-free. But this privilege is only there for citizen spouses. If one of them is a non-citizen spouse, or both of them are a non-citizen spouse, let's assume the case when one person, the deceased person is a citizen spouse and the receiving spouse is a non-citizen spouse. Anything they receive above the federal exemption limit will get taxed, and the receiving spouse, the non-citizen spouse, will have to pay the taxes immediately. So in order to avoid that, what we can do is to create this qualified domestic trust. So any such inheritance will be placed on the qualified domestic trust, and no taxes will be assessed on that trust as of that time. And it can be left in the qualified domestic trust, and the surviving spouse will get all the benefits through that. And eventually when they pass away, I mean, if there's any taxes to be paid, that will be paid off at that point. So as I said earlier, currently the federal exemption limit is 11.7 million per person. Together you will have 23.4. I believe my math is right. So you'll be fine if you're within that range. Okay. So what's the purpose of having a revocable living trust? It's a will substitute. I'm not saying that you have to avoid a will by just creating a trust. You need that also. I'll get to that in a few minutes. And the revocable living trust, it benefits you during your lifetime. And upon your passing away, your assets will be seamlessly transferred to your beneficiaries. And you will have the legal right to manage and control your assets during your lifetime. And after you're passing on to the your successor trustee. It could be a spouse or whoever you're nominating as a successor trustee. They'll be able to manage and control assets and distribute it to the beneficiaries accordingly. You can also leave instruction to your trustee regarding what to do with your certain assets, what kind of investment you want to do, or you want to take care of your pet. We have seen the situation also. You want to make sure your pet is taken care of, or there are certain specific instructions you want to leave regarding how you want your children to receive assets. Some people tend to say that only if they get a bachelor's degree, they'll be entitled to any kind of benefit. I mean, with the distribution. I believe that's far-fetched, but still, those are instructions you can leave in your living trust. And you will also name beneficiaries. Mostly it will be in a normal family scenario, it's your spouse and children. And some people who are unmarried, they nominate their parents or siblings or anybody else who they like to. You can also nominate charities in the worst case scenario. If nobody survives, you can also nominate charities to inherit your assets. And this also gives guidance to your trustees and your beneficiaries and anybody you're nominating. And you will also have a remote contingent beneficiary clause. That happens when, let's say, in the case of a husband, wife, 2 children kind of scenario. Let's say everybody is going in a car, going for a vacation. Let's say they got into an accident and everybody passed away. I mean, it's a most unfortunate situation, but in that even, what will happen to the assets that they leave behind? That will be addressed through a remote contingent beneficiary scenario. That clause will decide who it will go to. You can choose to leave it to your other beneficiaries, like your parents or siblings, nephews or nieces, or charities if you choose to. That's something you can do. Most case scenario, I've seen them nominating to their parents and siblings, that is called the heirs at law. It'll be distributed to them accordingly by the trustee. And the living trust also avoids probate. So whatever I discussed about probate earlier, that'll all be avoided by creating a living trust and transferring all of your assets into it. Transferring, the other name for that is also called funding. I'll also explain that a little more. So who's a trustee and what's their role? So the trustee is the person you're nominating to manage your trust when you're not there. You will be, when you're nominating, when you're creating a trust, you will nominate yourself as the initial trustees. If you're married, you and your spouse will be the initial trustees. And if something happens to both of you, you will nominate maybe, let's say if you have a sibling here or a friend here, whoever you're nominating, they can serve as a successor trustee for you. They will manage the trust until the final distribution is given away to your children at a certain age. Okay. So they hold a duty of fiduciary. We call it the fiduciary duty. It's a position of trust and confidence, and their responsibilities are held in high standards. So if they breach their fiduciary duty, they can be sued and they can be in big trouble. Okay. For example, the trustee cannot use your trust assets for his or her own personal use or benefit without your explicit permission. Instead, the trustee must hold and use the trust assets solely for the benefit of the trust beneficiaries. That is their duty. They have to make sure everything, the trust is managed properly, with prudently, and you have to act on the best interest of the trust and the beneficiaries. Okay. But the only benefit a trustee can have is they are entitled to compensation for their time and services, right? So otherwise, they are not allowed to do any kind of self-dealing. They cannot put their interest first before the trust and the beneficiary. So as I said, it's a duty of high standards. They are held in, if they kind of do any kind of mismanage, they can be sued and they'll be in big trouble. Okay. And also one more thing I wanted to mention, that you could also nominate trust departments. Banks have trust departments. They're also called the corporate trustees. They can also serve as trustees. So instead of the people you're nominating, your family members or friends, sometimes I have seen some clients who are not comfortable nominating their family or friends. They choose to use a corporate trustee, which is like banks. Banks have trust departments and they manage trust on a regular basis. They have all the resources and they know what they're doing. They are fully equipped, and also their fee will be higher than definitely what you'll be paying your individual trustee. Also, there are professional fiduciaries who also serve as trustees. They are bonded, and they also serve as trustees. That's part of their job. So they will just do things by the book, and again, they'll be paid according to their fee scale. Okay. So the next issue is about the funding of the trust. Once you create a trust, you put down, you wrote down who your beneficiaries are, who your trustees are, how you want the distribution to happen, who your remote contingent beneficiaries are. What is the next step? The next step after preparing your trust, signing it, notarizing it, and having a fully executed trust, the next step is to move all your assets into the trust. And how do we do that? The first step is by preparing and recording deeds, transferring your real estate into the trust. So if you own a real property here in California or any other state, if you own a real property, you need to transfer the title of that real property into the trust. That is achieved by creating a trust transfer deed. Sometimes it's done through other deeds too, quitclaim deed on other things. You transfer title from your name to the name of the trust and record it with the county where the property is located. And once that is done, your property will be officially part of the trust, okay? And it will not go through probate. The next step, another is to transfer bank accounts and stock and bond accounts or certificates to the trust. So this is the event when none of your accounts are beneficiary driven. So not all of your bank accounts or stock accounts are beneficiary driven. If it is not a beneficiary driven account, you have to retitle that account into the trust. Okay, you can reach out to the financial institution and they will help you with that process. You just need to give them the copy of the certification of trust, which we will provide to you, and they will help you to transfer the account into the trust. Once it is transferred into the trust, that will also be officially part of the trust, and that will avoid any probate with respect to that particular account. The third is changing the beneficiary designation on retirement plans and life insurance policies. This is put in a different category because retirement plans and life insurance policies are always beneficiary driven accounts. So you need to nominate beneficiaries. They are the type of accounts that bypass probate. Probate does not happen to these kind of accounts because it is a beneficiary driven account. So as I said earlier, you can keep your spouse if you're married as a primary beneficiary. And if you have minor children, I would not recommend nominating them as a secondary beneficiary because they are not going to get the proceeds of the life insurance or the retirement plans while they are minors. And they will get a check when they're 18 years old. Okay. So keep the trust as a secondary beneficiary. That's my recommendation. Okay. And so whatever the assets or the proceeds will come into the trust, and the proceeds will eventually be distributed to the beneficiary through the trust eventually. So another question we always see is, why do we need to have a will when you create a trust? When you have a trust, you still need to have a will, and we will have another will called the pour over will. It has a pour over provision. The purpose of that is anything left out of the trust. Let's say you purchased another real property and you did not move that real property into the trust. Now that's out of the trust and you pass away. And so now this property, the left out property, will trigger probate. So this pour over will be activated at this point, and the pour over will help transfer that real property back into the trust through the pour over provisions. But it has to happen through probate because will does not avoid probate. But the judge will know that there's a pour over will, everything kicks back into the trust, and it'll be distributed accordingly. Okay, so this is kind of a leftover catch-all provision. Okay. And the will is the document that you will be nominating guardians for your minor children. Okay, that's where you nominate your temporary and permanent guardians. So they can take care of your children if something happens to both of you. Your friends and family you nominate, they'll be able to take care of the immediate custody and pass it on to the permanent guardians. And so what is the difference between the will and a trust? Okay. So main difference is, in a will, the will is just a document you have signed as of, let's say you sign a will today, it's just a document. It doesn't have much power at this point. But the trust at the same time will be activated from the time you sign the trust you have created a trust, and you can start moving all your assets into it, and you can start operating your trust from that point. The will get the power only when you pass away. Okay. The will does not avoid conservatorship. The will does not avoid probate. The will is a public document because it has to go through probate, and there is possibility that the creditors taking advantage due to the public information. Okay, and the trust is a document that will allow you to control your assets and instructions during your lifetime. So it's a once you sign, notarize it, it's valid from that point onwards, and you can start operating using the trust. You can be the trustee, you can move things into the trust, take it to the trust, buy, sell, you can do whatever you want with the trust. It's an active document from that point. And it'll also address issues due to issues of conservatorship. That is when you're incapacitated, who will manage your trust? It's taken care of in that scenario. It can avoid probate. So by creating a living trust and funding everything into the trust, it can completely avoid probate. Make sure everything is funded into the trust properly. And this is not a public document. This is more of a private document. It stays with you and maybe with your lawyer. And it's only if you choose to share it with any of your trustees or any other family members, they will have it. Otherwise, nobody else has it. It's more of a secure and private document. And it allows assets to be passed on to your loved one without any additional cost, delays, or drama. So once you avoid the probate, I mean, you can avoid the cost involved with the probate or any kind of delays, and things can be streamlined very easily if you have a living trust and if you fully fund it. It's very it's a no-brainer. It's one of the best things you can do for your family. Okay. So that being said, one thing I wanted to mention in particular is your having a living trust done for your family. As I said, the threshold limit is $166,000 in value. If your assets are worth more than that, it will help for you, your successors, your family members to have a living trust. And that can be eventually passed on to you through you will be nominating your surviving spouse as the primary trustee who will manage the trust during his or her lifetime. And after that, whoever your successor trustees are, they will be able to manage your trust until your children reach a certain age. You can also designate what age you want your children to get distribution of your assets. Legally, they're entitled at age 18, but it's not necessary that you give them all the assets at 18, because and 18 is an age where they are not mature enough or savvy with financials. They might not make good financial decisions, and might be still in college. They're more prone to influence by others. Sorry. And you can set a certain age. I would say you can set an age nothing less than 25. So by that time, they will be finishing their graduation, and they'll be able to inherit assets from that point onwards. And they can make a choice whether they want to take the distribution at this point or leave it in the trust. If they choose to take the distribution, they'll get it from that point onwards, and it'll become part of their assets, and they can do whatever they want from that point onwards. So, so those are the basic information I wanted to share regarding wills, trust, and estate planning. I'm open to take any questions at this point. So back to you, Lemon.
Okay. First of all, thank you very much, Swapna, for an interesting presentation and very informational.
Of course, thank you.
And yes, and just before getting into questions, I just wanted to take a minute and thank our sponsors, Way.com, for all your insurance needs. Thank you, Wilson Nitikad and team, and also Bibgior for all your fashion needs. Thank you, Vani Srijit and team. Please take their services as needed. So we have a lot of questions, Swapna. I mean, I know we have little time restrictions, but at the same time, I got tremendous amounts of questions, and let me jump into those right away. The one question coming from Krishna Das, which is pretty common with other people as well. There are 3 others ask a similar question. So the first one is, my daughter is a minor and we don't have immediate family members in the US. Can I nominate my brother or sister in India as a trustee?
Okay, I think your question is regarding whether you want to nominate somebody as a guardian, not a trustee, right? Trustee is the one who manages your trust, manages your finances. The guardian is the one who takes care of your minor child.
Yes. I mean, it is both parts, both.
Okay, all right.
Guardianship and then the trust. If I make a trust, can they be the trustee? So,
okay, I'll get to that. So with respect to guardianship, yes, you can nominate your brother or sister back in India to be the permanent guardian. And as I said earlier, you need to nominate somebody locally, a family friend or somebody you trust, to be the temporary guardian. So they can take the immediate custody of your children if something were to happen to both of you. Okay. And you can nominate a permanent guardian to be in India. That's not a problem. They can be permanent guardians can be anywhere, even out of country, not a problem. With respect to trusteeship, it's mostly desirable that your trustee is a US person, either a citizen or a US, at least a green card holder, or somebody who's here and who are going to be more stable here. But if that is not a possibility, let's say you don't have any family members, it's a very common scenario. We see it with most of our clientele. Most of our clients are Indian people, and most of them have the situation. What we recommend at that time is to have a co-trustee. You can nominate your family member, let's say your brother in India, and a friend over here, somebody whom you trust, to be as a co-trustee. So they can work together at that point. They will serve as a co-trustee. They'll have to work with each other in managing the trust and distributing assets to your beneficiaries. But the purpose is, the idea why you cannot nominate a non-US person who's out of country to be a trustee is IRS does not want to deal with somebody who has no ties with US. There are yearly taxes that needs to be paid in tax filings needs to be done every year, so that you need somebody who can do that, who's a US person with a social security number who can do that for you. So that's why.
Oh, that totally makes sense. So that brings an interesting question. I know there are a lot of fiduciary services available, third-party organizations, agencies do those kind of services. So first of all, whether your attorney group offers any fiduciary services, or do you recommend any fiduciary services for those people who don't have immediate family in US?
We do not serve as trustees in our capacity. We only help prepare the documents. But there are professional fiduciaries who provide services of trustees. And as I said, there are banks. Banks have trust departments who serve as trustees. And that's part of their job. They have all the tools and resources they need in order to manage your trust efficiently. But again, they have a fee scale. We used to use City National Bank because bigger banks like Chase and Bank of America, that kind of Wells Fargo, their minimum requirement is 2.5 million worth of assets as minimum to start serving as a trustee. So, but there are other smaller banks who can do for lesser than $2.5 million worth of assets. So their fee would be, from what I have known as 1.25% of the total assets, of the value of the assets every year. So that is their fee scale. But okay. I think it's still, what I would recommend is you can have these individual trustees as a primary or maybe even a secondary trustee, but having a corporate trustee as a third or as a last trustee is like a fallback, in that you don't have to pay them anything until they step in as a trustee. Okay, so in that even in case everything else fails, let's say the trustees you nominated are unable to serve as a trustee, or the trustee you nominated here let's say they pass away, they're incapacitated, they cannot serve as a trustee or for whatsoever reason, you have something to fall back on. That's like a last case scenario. If something were to happen, I would recommend keeping a corporate trustee as a fallback, so to say.
Okay. Another question that came on the line is, what would be the taxes for the trust? Say, if I establish a family trust and move everything, and if I'm not alive anymore, what happened? What kind of tax rate the remaining assets need to be paid regularly? What tax bracket they fall under? Will they use my social security number? For example, when the trust was formed, the trust is using my social security number as a primary identification number. So once I die, traditionally, I cannot use the social security number anymore. It's kind of a frozen state. But the trust is using that ID. Will that social security number be alive even after I'm dead? And where do that tax filing happen?
Okay, so one of the fact that you mentioned, that your social security number will be used as an ID for your trust. That's true. But once you pass away, your trust will become an irrevocable trust, and your social security number cannot be used as a tax ID number for your trust anymore. So at this point, your trustee will have to reach out to IRS and get a new tax ID number from them, and use that tax ID to file taxes going forward every year. And the other question was a little tricky for me because I'm not a tax expert, and I cannot really give you tax advice. But as I said, for estate taxes, California does not have any estate taxes, but the federal government has. As I said, it's $11.7 million worth of exemption per person as of this year. This would change as the administration changes. I mean, things can change. We just need to keep an eye out and see how things are turning around in the coming days. And for a couple, as I said, it's $23.4 million worth of exemption at this time. So you don't really pay taxes if you're within that bracket. But if you're above that, my understanding is at least the tax rate is 40%. Again, I'm not a tax expert, so you should not quote me on this. But,
yeah. That sounds good. Yeah. So another question that came on the line is, can family members who are not residents of the United States claim a share in assets of their kin in US? Essentially, can I distribute something to somebody outside in India? And what kind of tax bracket in that case will they be taxed when they take their share? Do they need to pay tax in the US? Again, it's kind of overlapping with the tax. Plus, is there anything? Do they need a social security number? How do they get identified? What are the parts you know about that?
Okay. Yes, you can have a beneficiary in India if you have to. Let's say sometimes people nominate their parents, for example, who is living in India as a beneficiary. In that event, what happens is the trustees that you have nominated here will make sure everything is distributed to the people, the beneficiaries that you have nominated. Even if it is somebody here or a portion is going to somebody back in India, it's the trustee's job to take care of such distribution after paying off all taxes and paying off all kind of administrative expenses. After that, they distribute it to the beneficiary in India. Okay. That being said, I don't know if there will be a tax in India while they are receiving this amount. Again, I am not an expert in that area. We'll have to talk to a tax expert in that, a CPA or CA for this issue.
No worries. Understood. So the question is, if we only have will, if the person only has will, and then this procedure goes to a probate, during that, in the will, if we identify somebody in India as a beneficiary at that point in time, what happens, right? Will the courts can recognize that? because then there is no trustee involved in distribution. So will that occur?
So instead of trustee, we have another person here. It's the personal representative, or also we call as the executor. So that person is doing essentially the trustee's job here. So the court appoints this person as the personal representative. If you have a will, you might be choosing an executor. Maybe let's say you chose your friend over here to be as an executor, and they petition the court to probate the will. The court will nominate, because you nominated this friend as an executor, the court will most likely accept that. And it's your friend who will have to make sure, identify one of the beneficiary who is maybe a family member in India. In the court, I mean, as long as all other expenses, any kind of let's say taxes and creditors are paid off, administrative expenses are paid off, the court does not mind distributing it to your family in India, if the case.
Okay. So I have another question coming from Rajesh. The question is, how much, what kind of cost one has to expect for executing a trust? My understanding is trust is executed by trustee. So is there any other cost that we have to pay to any governmental nodal agencies to execute the part of the trust? Just like a probate court need to be paid certain type of the fee structure you mentioned, like 4%, 3%, 2% for all that tier. Is there any kind of fees involved in executing a trust?
In executing a trust, the fees that will be, one main thing I can think is the trustee's compensation. So if it's a family member or somebody close to you, they might choose to waive their compensation, but as a matter of law, they are entitled to compensation. Okay, and any kind of expenses which are incurred in managing or administering a trust, that is all it would be. Let's say if you need to use the services of a investment advisor, so you need to use the service of a CPA, you need to use the service of a lawyer. That will all be part of the trust related expenses. I think those kind of expense will come in other scenarios also. So it's not something that is coming out of the blue, but yeah, I mean, the trustee's compensation and these kind of administrative expenses is what I can say.
So another question is, once we create a trust, do we need to, I assume we need to update the trust periodically to keep it more to the nature of a living trust, right? What kind of expense or cost it takes to do it? Is it just same like building a new trust, or is that at that time the cost is a little bit lower than? So what is kind of a normal maintenance period of trust in your experience?
Okay, once you set up your trust, unless you have to completely reinstate your trust, which does not happen very often, sorry. In that event, you can just do an amendment to your trust or a codicil to your will, as the case may be. Let's say if you want to change your trustee, you might want to do an amendment. You want to change your primary address, you can do an amendment. You want to change some terms of the trust. You want to add another beneficiary. Let's say you have another child. You want to amend your trust. So those are the amendments that comes up. The cost would be significantly lower than creating a trust itself, unless it is a reinstatement where, let's say the laws of the tax laws changed, and you need to probably restructure your trust completely. At that time, it will be like recreating your trust again. But otherwise, it would be a simple amendment, which is much less in cost.
Okay, thank you very much for that information. I know we have more and more questions pouring in, but I'm getting notification from my backend, like the time is flying much faster than expected. So here, what I'm going to refer to all my friends who are listening. If you have more questions, you can contact Attorney Swapna Anthoor directly. Swapna, can you share your phone number, which the people should contact you to take your service and ask their questions and all?
Okay, of course. I can also share my email ID. So my email ID is Swapna, SWAPNA at anthoorlawgroup.com. It's A like Apple, N like Nancy, T like Tom, S like Harry, OOR, law, LAW, group, GROUP.com. You can also send an email at info at anthoorlawgroup.com. And our office number is 510-794-2887. Okay.
Thank you very much for
Levon,
that information.
You can also feel free to
Yeah.
share my information with anybody who wants to get in touch with us. Yes,
Yeah.
you have my information.
Definitely, we are going to. So, dear friends out over there who's listening us, if you come through Bay Malayali, you will be, Swapna is offering a $100 discount to all Bay Malayali friends and family. So contact baymalayali@gmail.com for your discount coupon, and you can contact her and take all her services. Thank you, Swapna, for all your time, all the information. And once again, I wanted to thank our sponsors, wear.com for all your insurance needs, and VibGeor for all your fashion needs. This program will be stored in our YouTube channel, so you can go back and watch. If you have any questions or you missed any part, you can always play back and see it. It is in our YouTube channel. And also, dear friends, please subscribe our YouTube channel, so it will help us bring more and more financial literacy content and more other informational content that we as immigrants need to have. So with that, I know it's already a little late, so thank you everyone for listening, and thank you USA. Thank you. Good night, everyone.
Thank you all. Thank you for listening, and thank you, Bay Malayali, for this wonderful initiative. It's a privilege being here on this platform and being able to share this information with everyone. Thank you.